We welcome ladies.
नमस्ते, वेलकम मैम।
नमस्कार।
थाली हम बजाते हैं।
Suraj. Yeah, we welcome leadership. We are very proud moment for our Friday group. We are highly grateful to her. Leadership will start with garland with Chandrachud sir. Please, please not to stand there. Please go back. Just please, Raju Ramchandra sir. Come sir. Go back. Go back. दरवाजा
बंद कर दो।
बैक साइड आ जाओ और give a huge clap, Saman. No, this is it. Karpagam, sir. Justice Karpagam, sir, will give you. Please come one by one. Yadav, our secretary, please come here.
मैडम भाई
Please come here, please. Yadav, please come quickly. Yeah. Srivastava, Rachna Srivastava, our president, vice president, CJI. Yadav, please, our secretary, beloved secretary. Thank you very much. Sir, Nagarathnna sir here, please sir. Basant sir also is here, please sir, come sir. Yeah, please, he's come. Mr. B.V.NAGARATHNA, he came all the way from Hyderabad to attend this function. And one Mr. Mallikarjun also, young advocate from Kurnool, he came all the way from Andhra. Yeah, Basant sir, please come. Come Mallikarjun, please come. Yeah, please. Raju Ramchandra sir also is here, senior advocate. He has a great experience with the senior Chandrachud sir. Please, sir, where is sir? Please come, sir. We have a little bit. Please. If anybody, please come one by one. Yeah, come one by one.
बाकी मैडम जी।
Friends, we are going to start with the bouquet of flowers, then our introduction little bit, and main program something like. Now I give you myself on behalf of Friday Group to leadership. So give a huge clap. Rahul Agarwal and Amit Pratap Singh will give a bouquet of flowers to ladies. Please come, Rahul and Amit Pratap Singh. They're continuously helping me last 5-7 years. And Saket Gautam will give a bouquet of flowers. Please come, Saket. She is also continuously helping me.
Thank you.
Shobha Gupta, where is she? Shobha Gupta ji, please come here. Come quickly. Venkatramara Bhai sir, please come. Yeah, please. Shobha, please come. Wait, please. Shobha.
No, let sir, please.
Yeah, Venkatramara sir, all the way he came from Hyderabad.
Please sir।
Great. Ravan company, civil lawyers. Thank you very much, brother. Shobha ji, please. Shobha Gupta, please come. Justice Karpagam, sir, please.
Thank you।
Justice Karpagavani, you take it, sir. Basan sir, please come forward once again. Is the love and affection for you? There is a demand.
Please, sir. Please, sir. Please, sir.
Nagamutu sir.
Please, sir. Please, sir.
Sir, you take this side. Sir, please come. So,
Please hold this, sir.
Vijay Sangwan and Rahul Sharma. Vijay Sangwan and Rahul Sharma and Jyoti Parashar will be okay floor.
Thank you.
Sir, इधर हो जाइए.
Nobody else.
Rahul Sharma.
उस तरफ हो जाइए, sir. Yes, please, sir. Thank you.
Thank you.
This is Nagamutu sir. Nagamutu sir, please sir. Secretary or beloved secretary, Vikrant Yadav sir, he helped me a lot to get this podium and everything. Very, please. Give a huge claps.
Thank you.
Rachna Srivastava, please come forward. Our Vice President, recently elected before vacation. Not to stay backside, please come forward. Backside you go. Now we start our program immediately. Today is our 216th Friday group meeting. The topic is the legal and constitutional philosophy of Justice, Chief Justice Y.V. Chandrachud. Ladyship B.V.NAGARATHNA ji is going to address on that. Ladyship, we have to give a few details even though we have given earlier. We have total subscriber 30,600. That is our subscribers. Total views 14,79,000 as of now. This is our beloved Nagaratna ji addressed 86th viewers, 86,496 viewers. She had her own video on Hindu Succession Act. So that was addressed on 4/11/2022. Within 15 days, we have 50,000 viewers in our channel. It never happened in our Friday group history. I don't think any academic legal history also. Within 15 days, 50,000 received this message from Google, YouTube. Your viewers, not only in India, in Pakistan and United States also. What more we can manage? It's a great satisfaction. It's an evidence several times that they calculated. And now leadership is going. She's going to address our Friday group. The most welcome leadership, Lisa. 60. Mic लगाना सिर्फ.
Yes.
ये है ना इसमें Please.
Namaskar to everybody. Mr. G.Seshagiri Rao, advocate and organizer of the Friday group lectures, learned senior members of the bar, learned senior advocates, ladies and gentlemen. I am pleased to be amidst you all this afternoon after a hectic opening of the Supreme Court. I was wondering whether I could make this at all on Wednesday. In fact, I confessed to Mr. G.Seshagiri Rao I should have taken the next Friday instead of this Friday. But Mr. Rao persuaded and he said, no, 10th of July is the anniversary, so we cannot postpone it too much. And I had already given my word for 12th of July. 12th of July is important in the legal and constitutional history of India, I would say, because it is on this day that Chief Justice Yashwant Vishnu Chandrachud was born. And it is coinciding with your Friday group meeting. So I thought, what is a more apposite topic than this to speak today on his birthday? Today is the 216th meeting of the Friday Club. I just heard about the thousands of subscribers that this club has and lakhs of viewers electronically. Apart from the large number of senior advocates and advocates who are attending in person today, I am overwhelmed. So let us pay our tribute to Chief Justice Y.V. Chandrachud today on his 104th birth anniversary. And hence my topic is the legal and constitutional philosophy of Chief Justice Y.V. Chandrachud. Many of you may have appeared before him. I am sure Mr. Raju Ramchandran must have appeared before him. There must be many others. But what is important is that so many of the advocates, whether senior or junior, designated or not, may not have appeared before him. And I feel as a student of history that it is necessary to remember the past veterans, the giants of the profession, and those who adorn the bench in the legal profession as well as on the bench. I am only making a small beginning today so that the Friday group continues to have this theme of remembering legal giants not only in the Supreme Court but elsewhere also through the series of lectures that you organize. So coming back to the legal and constitutional philosophy of Chief Justice Y.V. Chandrachud, as I already told you, he was born on 12th of July 1920. As per the Hindu calendar, that was Harishayana Ekadasi, or what we call in the south, sometimes we also call it as Prathama Ekadasi. It is a very important day. And what is significant is that when he passed away in 2008, which was 2 days after his birthday, on 14th of July, it was Harishayana Ekadasi. It is a very significant day, and you will please look up either through Wikipedia or Google or whatever, how significant that day is in Hindu calendar. So with that brief in significance of the day of his birth and passing on, let me move on to say that he graduated in the year 1940 in History and Economics from Elphinstone College, Bombay. He got his law degree in 1942 from ILS Law College, Pune, where there are many veterans. Any elucidation of Chief Justice Y.V. Chandrachud's jurisprudential contribution would be incomplete without an allusion to his stint at the Bombay Bar and the bench at the Bombay High Court. He enrolled as an advocate in 1943. That is the year when my father joined ILS Law College as a student, and he left his remarkable footprints both as a lawyer and a judge. He was equally adept in both civil and criminal matters. He prosecuted the well-known Nanavati case in the Bombay High Court. The successful prosecution of Nanavati showed his forensic ability as a lawyer on the criminal side. His performance in that case is reputed to be one of the best ever in the Bombay High Court. Chief Justice B.V. Gajendra Gadkar, in his autobiography, To the Best of My Memory, recollects about Justice Chandrachud's unique style of advocacy when he was a young lawyer, characterizing his style as both eloquent and persuasive. It is remarked that Justice Chandrachud's advocacy was the perfect balance between attractive oratory skills coupled with impeccable legal knowledge. He was a part-time professor in law which aided him in his oratory skills. He was appointed as a judge of the Bombay High Court in March 1961. Intellectual brilliance, profound scholarship, liberal judicial vision and craftsmanship, precision of thought and elegance of expression characterized the judgments rendered by him in the Bombay High Court and thereafter in the Supreme Court. He was elevated to the Supreme Court in March 1972 and was appointed as the 16th Chief Justice of India in February 1978 and has the distinction of being the longest serving Chief Justice, having served in that post for 7 years and 4 months, which is a record which is indeed difficult to beat. I fondly remember Justice Chandrachud for his unassuming nature, his simplicity complemented by his unmatched sagacity. The gentleman judge was very fond of cricket, a gentleman's game, and it is said that he sometimes used to inquire about cricket scores while in the courtroom in order to cool down frayed tempers. I was a student when I was in Delhi in the 80s and he was the Chief Justice of India, and therefore I could only interact with him socially. Unfailingly polite, even at a time when he held the highest judicial office in the country, Justice Chandrachud never expected anyone to walk up to him, to greet him or acknowledge his presence. If he recognized somebody in a gathering, he would with utmost modesty, true warmth and amiability greet them, having no regard to such other person's age or standing. This politeness was carried with him to the bench. It is said that in complex cases, he wrote down a proposition or a question to be asked to a member of the bar and tested it in his mind before putting that question to the advocate. Chief Justice Chandrachud retired on 12th July 1985. His retirement years were very active. To sum up, he was a torch-bearer of a generation and has left a distinct mark on life and law. I shall now proceed to discuss various themes which would characterize Justice Chandrachud's judgments, which may be more aptly described as the constitutional or legal philosophy guiding his decisions. As I already mentioned, he was at home at all branches of law. He rendered over 480 judgments in the Supreme Court, covering every ray of the spectrum in jurisprudence. I may start with the controversial basic law doctrine, basic structure doctrine. As students of constitutional philosophy, we are struck by his ideas of judicial moderation, separation of powers, and a strong sense of institutional balance which seeks to preserve the balance of powers under the Constitution. The narrative of Justice Chandrachud's philosophy on the balance of powers under the Constitution has to begin by considering the controversy before the Supreme Court in H.H. Keshavananda Bharati versus State of Kerala. The verdict can be found in 11 separate judgments. 9 judges, including Justice Chandrachud, signed a summary statement which records the seminal concept of basic structure of the Constitution and renders the same immune to amendment by the Parliament. Further, it is necessary to refer to his opinions in Indira Nehru Gandhi versus Raj Narayan, Minerva Mills versus Union of India, and Vaman Rao versus Union of India, wherein he fostered and nurtured the basic structure doctrine. The latter two cases I would not be dealing with in detail because they are a subject matter of a 9-judge bench decision of which I am a part. Therefore, I will start with the Indira Nehru Gandhi's case. The balance in the vision of Justice Chandrachud articulated in this judgment has rendered flesh and bones through the basic structure doctrine. Having acknowledged that values of democracy, equality of status and opportunity to all citizens, right to freedom of religion and government based on rule of law formed a part of the basic structure of the Constitution and were unamendable on that score, Justice Chandrachud, speaking for the bench in this case, evaluated whether, by placing elections of the Prime Minister and Speaker of the Lok Sabha beyond the purview of judicial review, any of the aforesaid pillars of our constitutional philosophy were sought to be displaced. He possessed the traits of a scholarly statesman, and these traits were implicit in his balanced judicial approach. In Minerva Mills, he poignantly added that the attempt to eternally defer the constitutional promises guaranteed by the fundamental rights on the pretext of securing governance as mandated by the directive principles was merely an instance of words being bandied about in marbled halls, which say much but fail to achieve as much. The basic structure doctrine was further distilled by the Supreme Court in Vaman Rao versus Union of India, when speaking through Chief Justice Chandrachud, who clarified Article 31 capital B of the Constitution. Justice Chandrachud's somewhat complex views on the inherent limitations in Keshavananda Bharati and the vigorous application of the basic structure doctrine in Indira Nehru Gandhi, Minerva Mills and Vaman Rao raised some questions those days. According to Professor Upendra Bakshi, there is a shift in the views of the learned judge and a disagreement with his own positions, and has raised remarks to the effect that, open inverted, we have under the same name two different Chandrachuds, close inverted. I find that the said comment was not necessary because he had to follow the precedent in Keshavananda Bharati subsequently on the basic structure doctrines and apply it in the subsequent cases. Be that as it may, the nation would remain indebted to Justice Chandrachud for firmly protecting its precious heritage, that is, the Constitution. Had the basic structure of our Constitution not been immutable, our democracy would have struggled to save its sanctity. Beyond the parameters of restraint and moderation, as I just outlined, Chief Justice Chandrachud had no hesitation in asserting the importance of enforcement of rights of citizens. We all have heard of the case of Rudul Shah versus State of Bihar, where he granted cash compensation to a victim of unlawful incarceration, violating his fundamental rights. On recognizing that the amount of compensation awarded by way of judgment was not sufficient for the nature in which Rudul Shah's liberties were mulcted, when he was kept confined for 14 long years after an acquittal, the compensation awarded in the writ petition was stated to be only an interim one. At that time, compensation for violation of fundamental rights was a novel constitutional pedagogy. Subsequent to the decision in Rudul Shah, compensatory relief has been granted in several cases involving abrogation of fundamental rights as a means to civilize public power. The judicial revolution championed by Justice Chandrachud by way of the radical reading of Article 21 of the Constitution chartered a new base in rights jurisprudence in India. In Maneka Gandhi, who questioned the validity of having her passport impounded by the authorities, a new lease of life was given to Article 21, and the distinction of creating the right to travel abroad as a facet of the right to life was established. By way of his separate but concurring judgment in Srimati Maneka Gandhi versus Union of India, Justice Chandrachud brought about a metamorphosis in the earlier judgment of the case in Satwan Singh Soni, where it had been held that no person could be denied the right to travel abroad other than by adhering to the procedure established under law, which procedure had to meet the mandate of Article 21 of the Constitution. That a procedure which meets the mandate of Article 21 was still subject to a challenge under Articles 14 and 19 was emphasized. In holding so, the ratio in the decision of A.K. Gopalan, which provided that fundamental freedoms were mutually exclusive, was varied. This judgment has many proteges to boast of and has enabled the creation of right to privacy, right to health, right to a healthy environment, among others. Justice Chandrachud continues to influence judges to this date as they draw inspiration from his crusading spirit to accord a plethora of rights. On the other aspects of the case in Maneka Gandhi, that is, arbitrariness in state action being antithetical to Article 14 of the Constitution, he agreed with Justice Bhagwati on the exposition and its content. In the same vein, Justice Chandrachud in Olga Tellis versus Bombay Municipal Corporation, which was pronounced just 2 days before his demitting office, he deciphered the holistic meaning of the term life as appearing in Article 21. One fruitful outcome of this is the recognition of right to livelihood as falling within the umbrella of Article 21. His paramount consideration was the well-being of the Indian people, and this sentiment has been summed up in a single sentence in Olga Tellis, which reads, open quote, "Human compassion must soften the rough edges of justice in all situations," unquote. On the theme of prison justice and rights of a convict, Justice Chandrachud's decision belonged to the reformatory school of thought, and he fashioned many ways to alleviate the psychic distress that prisoners are faced with by employing humanizing ways to protect the remnants of their fundamental rights and freedoms. In Bhuvan Mohan Patnaik versus State of Andhra Pradesh, Justice Chandrachud, as early as in 1974, rejected as wrong the idea that a convict, when confined in a prison, is lost to the world and is simply expected to suffer silently through any treatment meted out to him. Accepting the submissions of Sri R.K. Garg, Justice Chandrachud held that a conviction would by itself entail the deprivation of certain fundamental freedoms, such as the right to move freely or the right to practice a profession. However, a conviction could not be an impediment to the precious and inalienable right to life and personal liberty, unless deprived in accordance with the procedure established by law. Another glorious recital on the theme of equality and natural justice to be accorded to a convict is the decision of Mittu versus State of Punjab, wherein Justice Chandrachud, speaking for himself and the other judges on the bench, arrived at an unimpeachable and eminently reasonable conclusion that even a life convict had the right to persuade the court to grant him a sentence lesser than a death penalty for a murder committed while serving life imprisonment. Thus, Section 303 of the Indian Penal Code, which made it mandatory to award death penalty for a murder committed while serving life imprisonment, was struck down as unconstitutional. Justice Chinnappa Reddy delivered a separate but concurring judgment, agreeing with the learned Chief Justice. However, Justice Chandrachud could not bring himself to vote against the constitutionality of death penalty in Bachchan Singh versus State of Punjab, even having regard to Article 21 as metamorphosed in Maneka Gandhi, and subscribed to the rarest of rare doctrine evolved by Justice R.S. Sarkaria. Whether the death penalty is justified or not has been a matter of debate for penologists, sociologists, jurists, judges, legislators, law enforcement officials, and students of law. In my view, the beauty of Justice Chandrachud's judgment in Bachchan Singh was that the antithetical views of the retentionists and abolitionists was probed only till required and not beyond that. However, in this case, Justice Bhagwati dissented. The idea of inter-se balance between the organs of the state under the Constitution is also present in the decision of A.K. Roy versus Union of India. Vital amendments were made to Article 22 of the Constitution with a view to strengthen and safeguard rights of detainees. However, the Union Executive, even after considerable delay, failed to exercise its power to bring these amendments into force. In keeping with his strong sense of checks and balances under the Constitution, Justice Chandrachud, speaking for the majority, ruled that it was not open to the Supreme Court to direct the Supreme Executive to bring these amendments into force. I take note of the prologue. Justice Chandrachud's judgment in A.K. Roy states, wherein he consciously said, and I quote, "Personal liberty is a precious right, but it has to be subordinated within reasonable limits to the greater good of people," unquote. His humanistic approach to imprisoned persons can be gleaned from his judgment on the right for journalists to interview prisoners. The case of Prabha Dutt versus Union of India revolved around the interview of the two infamous convicts, Billa and Ranga, who had murdered two Chopra children in the year 1978 near the Ridge in Delhi, resulting ultimately in death penalty being awarded to them by the Supreme Court. Chief Justice Chandrachud did not deter the court from appreciating the right of a journalist to interview the two prisoners, namely Billa and Ranga, who were sentenced to death. His crusade for women is noted in several judgments, two of which I would recollect. Justice Chandrachud has authored several judgments to which elements of law and judicial process converged to serve as effective agents of social change. Among them is Gurupat versus Hirabai, wherein he has employed his expansive interpretative philosophy to alleviate the suffering of a woman. In Gurupat, he realized the plight of the Hindu widow and interpreted Section 6 of the Hindu Succession Act in a manner that the widow was able to secure a share much larger than what she would have got if the provision had been interpreted textually and strictly under the Bombay School of Hindu law. Justice Chandrachud strongly believed, and I quote, that common sense, which is a cluster of life's experiences, is often more dependable than the rival facts presented by warring litigants. I don't wish to go much into the famous Shahbanu case where the Constitutional Bench ruled that Section 125 was applicable to a Muslim woman, but you know what happened thereafter. The 1986 Act came and subsequently the latest decision of this court. In Shahbanu's case, the experiences of a widow who has been divorced and her trauma made this court grant the relief to her under Section 125 of the CRPC. But the later developments by the enactment of the Parliament in 1986 and the confusion caused thereafter could only be resolved only recently. He maintained, Chief Justice Chandrachud maintained, that a judge did not have to face the prospect of being driven to the street in order to realize what it means. His training, legal equipment and experience of life are his tools of education and social awareness. Thus, what he intended was that even though a judge may be construed to be within the ivory tower, must nevertheless have the pulse of the Indian society in his mind and in his heart. Therefore, Justice Chandrachud's keen thinking and his astute legal mind, developed through an understanding of both law and life, has been channelized towards redressing issues at every level be it aiding and encouraging the average citizen in resolving his everyday problems, or in seamlessly rendering judgments in the areas of constitutional law, private international law, law of taxation, company law, amongst others. A decision which is till date a masterpiece in the area of private international law or conflict of laws is Satya versus Teja Singh. This judgment was rendered to suppress the notoriety created by what are commonly called Nevada divorces. Nevada is one of the states in the United States of America which offers domicile of the state to a person residing for a period longer than a mere 6 weeks. This concession given by the state had attracted many errant husbands who would obtain a domicile of Nevada and file a petition for divorce in a court in Nevada. More often than not, the wife would not appear and the husband would conveniently obtain a decree of divorce from a court outside the jurisdiction in which the wife resided. Recognizing that such a practice was a patent abuse of the process of law and was unfair and unjust to absent wives, Justice Chandrachud refused to recognize and enforce a decree of divorce obtained from a court in Nevada. Aptly identifying that the husband had indulged in forum shopping or forum hunting, Justice Chandrachud observed that the respondent husband had invoked the jurisdiction of the court in Nevada by portraying incorrect jurisdictional facts. This decision is a testament to the enhanced degree of practical scholarship of Justice Chandrachud, coupled with the fact that that which applied to the provisions of Section 13E of the Civil Procedure Code to hold that the divorce decree had been vitiated by fraud. Recognizing the harsh reality of private international law, Justice Chandrachud cautioned against blindly adopting rules of private international law in such matters. His decision in Narayan Ganesh Dastane versus Suchaita Narayan Dastane threw up many questions, for he refused to give divorce to a couple, although he concluded that there was cruelty. This was under Section 13 of the Hindu Marriage Act. Although based on the evidence led, it was held that the conduct of the respondent wife amounted to cruelty. The refusal for grant of divorce was because he observed the fact that the couple continued to reside together and had 3 children would lead to the court to believe that the husband had condoned and forgiven acts of cruelty on the part of the wife. The decision is a testament to the fact that Justice Chandrachud in his judgments often proceeded to conduct a psychological foray into the minds of the litigants, particularly in family law cases, before indulging in the exercise of interpreting the legal provisions and applying the same to the case before him. Next, his decision in Needle Industries India versus Needle Industries New India Holding Limited demonstrates his intricate knowledge and understanding of the disputes between shareholders plaguing the corporate world. In this decision, while developing the law on the fundamental question as to what amounts to oppression, Justice Chandrachud developed what is today one of the most paramount rules in company law, that is, that conflicts between the shareholders should be checked in order for the company to function efficiently and profitably. A polymath in the truest sense of the term, Chief Justice Chandrachud performed with distinction even the administrative duties required to be performed by a Chief Justice of India. His personal philosophy that, quote, integrity is indeed the sine qua non of merit and suitability. No person can be considered as possessing merit and suitability if he lacks in character and integrity, unquote, guided his decisions as to the identification and recommendation of judges for elevation to the apex court. During his tenure as Chief Justice, he appointed as many as 14 judges to the Supreme Court a few of them who went on to become Chief Justices of India. The Chief Justice of the Supreme Court is also the master of the roster, as you all very well know, and composition and constitution of benches of the court assume significance. Justice Chandrachud has been described by Justice Chinnapareddy as the master of the art of constituting benches to get the best out of the judges. He molded decisional outcomes not only through his judicial pronouncements but also by constituting balanced benches which were capable of rendering binding, consistent and stable pronouncements. One word about ADM Jabalpur versus Shivkant Shukla. It is clear that despite the noble effort of Chief Justice Chandrachud to publicly apologize for his views in ADM Jabalpur, he was not able to revise his position. The ADM Jabalpur case was formally overruled in Justice K. Puttaswamy versus Union of India by a bench which comprised of none other than Honorable Dr. Justice D.Y. Chandrachud, his illustrious son, the present Chief Justice of India. I am greatly comforted by what Dr. Justice D.Y. Chandrachud shared after the judgment in Puttaswamy was pronounced, and I shall quote him. I think my father would agree with the ruling. I have always had this feeling that through his life he believed he was wrong in the ADM Jabalpur case. I think he would have done it differently had the circumstances been different. Unquote. In the above backdrop, it would be useful today to recall the famous words of Justice Hansraj Khanna, who gave his famous dissent in that judgment in the penultimate para when he said, quote, "Before I part with the case, I may observe that the consciousness that the view expressed by me is at variance with that of the majority of my learned brethren has not stood in the way of my expressing the same. As observed by Chief Justice Hughes, judges are not there simply to decide, but to decide them as they think they should be decided. And while it may be regrettable that they cannot always agree, it is better that their independence should be maintained and recognized than that unanimity should be secured through its sacrifice. A dissent in a court of last resort, to use his words, is an appeal to the brooding spirit of the law, to the intelligence of a future day, when a later decision may possibly correct the error into which the dissenting judge believes the court to have been betrayed. This is a classic example, ADM Jabalpur and Puttaswamy's case. During the years of Chief Justice Chandrachud, the Supreme Court had made several innovations, the most important being the procedural innovation in the realm of judicial review by way of the public interest litigation. The doors of the Supreme Court were opened to large masses of people who flocked for justice for enforcement of the fundamental rights, particularly Article 21 of the Constitution. Chief Justice Chandrachud, along with Justice Bhagwati, who was the senior most judge of this court, Justice Krishnaiyer, who was there in 1980, and Justice Chinnapareddy, ensured that public interest litigation triumphed those years. The trend in the accepting public interest litigation has continued, but the court has now become very cautious in accepting the right kind of litigations which come as public interest litigation. No attempt to detail the phenomenal jurisprudence of Justice Chandrachud can do justice to his strength as a judge who cared deeply for India. He presided over the Supreme Court with distinction, and even when his tenure as a judge of the Supreme Court brought him anguish, particularly with regard to the first judge's case, S.P. Gupta versus Union of India, he remained in word and deed a gentleman judge. According to George H. Gadboy Jr., quote, His tenure as Chief Justice of India was by far the longest in the Supreme Court of India's history and spanned years of momentous changes in the country, including 2 presidents and 4 prime ministers. As his tenure progressed, relations among the brethren became increasingly fractious. Chandrachud was a man of the middle and struggled to maintain some collegiality among strong personalities to his left and right. It could not have been much fun being CJI during those years." Unquote. I once again thank Sri Sheshagiri Rao and Friday Group for inviting me to deliver this lecture and to recollect on the varied achievements of Chief Justice Yashwant Vishnu Chandrachud. Before I conclude, I must impress upon all of you the importance of this Friday Group. You all know that this is a group where knowledge is shared. And what is the meaning of sharing of knowledge? A teacher shares his knowledge with his students. A senior shares his knowledge with his chamber colleagues, juniors. An elderly person shares his knowledge with youngsters. By sharing knowledge, do we lose anything? But by sharing our material resources, the person who donates, the person who gives may lose something. But according to me, by sharing knowledge, the person who gives enhances his knowledge. And that is what is the motto of this Friday Group. I must congratulate Mr. Sheshagiri Rao, advocate, the administrator and organizer of this Friday Group, and each one of you who turn up in large numbers for these programs, to hear persons who come to address you. As a result, you are able to directly gain so much instead of going through the books or the internet. This, I think, is very important. And on the conclusion of the 9th anniversary of this group, I wholeheartedly congratulate the administrator and each one of you for this. Continuing any effort or endeavor for 9 years or more is not an easy thing. To continuously endeavor and attract attention to an activity such as a learning activity as it is in this Friday Group is almost impossible, particularly after a Friday, after especially petitions are disposed of or dismissed, as you may say, or even allowed when learned members of the bar would like to return and convey the news to their respective council from various parts of the country or advocates. It is so heartening to see that so many advocates have gathered here, and I once again thank Mr. Sheshagiri Rao for taking this trouble and each one of you for being present. And I must say that sharing my little knowledge about Chief Justice Chandrachud and his judgments, I have only discharged my rina, and it is an obligation not only to him that my family has, but to each one of you who has attended and listened to this talk with so much of attention. Thank you one and all. Namaskar.
Now friends, let us give a standing ovation to Lady Chief.
Thank you.
Thank you very much, Ladyship. So highly intellectual, enlightening, so much knowledge. I never have in my all these years so much of knowledge, information, so many judgments about Senior Chandrachud. So we are all grateful to you. Really, it's a great learning process. It's another great experience, but the way the moment I met you, the way you express about your concern about me and the Friday group and senior Chandrachud, it's unbelievable. Even yesterday, 1 o'clock also. Thank you very much. Before not to leave, there are 1 or 2 important things that is in your interest, in fact. Please not to leave. I asked Gitanjali Sharma will give a vote of thanks. This is a mischievous girl, but in our group, I request, please come. Come, Gitanjali, come.
It is an immensely delightful moment for me to be standing here on behalf of the Friday group expressing thanks and gratitude. I deeply thank Hon'ble.Mrs. Justice B.V.NAGARATHNA for gracing this 216th Friday group meeting, which holds the significance of marking completion of 9 years since the Friday group took shape in July 2015. It does not get any more portentous than Justice Nagarathna elucidating the legal and constitutional philosophy of former Chief Justice of India, Honorable Mr. Justice Y.V. Chandrachud, our longest serving Chief Justice so far, on his 104th birth anniversary. Cricket scores being inquired about by Justice Chandrachud to cool frayed tempers is one of the coolest courtroom anecdotes I have heard so far. Justice Nagarathna alluded abundantly to the legal and administrative acumen, precision, sagacity, intellectual range, humanitarian outlook, and scholarly statesmanship of Justice Chandrachud. Justice Nagarathna's reference to the judicial revolution brought about by Justice Chandrachud by a radical reading of Article 21 was germane to today's discourse. A remarkable coincidence being that just 2 days back we had Justice Nagarathna deliver a judgment on Muslim women's right to maintenance, which is unmistakably redolent of the 1985 Shah Bano case that was delivered by a 5-judge bench, which was led by Justice Y.V. Chandrachud. That was almost 40 years back. Thank you, ma'am, for taking us on this intellectual journey. A big thank you to G.Seshagiri Rao sir, the administrator of the Friday group and the unrelenting crusader of this educational initiative. Also thanking the beloved members of the Friday group who are the very columns of support on which we build our efforts. Special and heartfelt thanks to all the attendees here today, respected former judges, senior advocates, friends. It's because of continuous support like yours that motivates us to go on. Thank you all. Have a good evening.
On behalf of you, on behalf of Friday group, on behalf of me, this small cup we are presenting to leadership. You all will get some. I am going to present all of you. It's available.
Both sides. Coffee and then give. Unwilling of that. Yes.
Wait for 5 minutes, it's opening. Thank you, Ranjit. Not taking your name. Thank you very much. Another senior advocate here. And Suresh, he came all the way from Hyderabad, another youngster. Thank you very much, Suresh. And another few prominent advocates. It may not be visible, but I can say grateful to you. Okay. Leadership, another important memento on behalf of Friday group. Please kindly see.
सर प्लीज सामने देखिएगा फेस सर इसका चेहरा नहीं आएगा ना सर डाउन करिए प्लीज मैम थैंक यू
Krishna's chariot.
Like this one.
Yes.
Handle carefully.
Reminds me of the common man and the common woman.
It's like agriculture country.
Yes.
I think you brought it from all the way from Hyderabad.
Andhra, here it is. Andhra told. Clay. Clay and wood. Thank you, sir. This was not necessary.
Memory.
Got to go for a very big house. For a big house.
Distribute them. Sweets, we can sweets we are distributing. Meanwhile, coffee is out.
As always. Volunteers.
एक और इधर लो
किसको दे रहे हो? मैम को दे रहे हो? पता नहीं। सर्विस
Why don't you keep them in the cup itself?
The cup is meant for something else.
No, we will give the sweets only. Pens have become fancy, antiques now. This milk into it, not even for signature, I don't know. Signature in check की जरूरत ही नहीं है, सब कुछ बंद हो गया।
अरे यार मैंने बहुत दिनों बाद एक सीनियर को चेक किया मेरा बाउंस हो गया
हाँ, सिग्नेचर नहीं मिली। मेरे जितने